Committee on Judiciary and Civil and Criminal Jurisprudence will now be called to order. Due to the fact that we're missing a couple members, we're going to start in a subcommittee. This is a reminder that all bill sponsors will have 3 minutes to present. I think we have one bill today, or two bills today, where the sponsors are going to present together. The first two witnesses, for and against, will have 5 minutes. We'll alternate back and forth. All other witnesses, for and against, will have 3 minutes. And as the hearings go on, you may hear us move that to 1 minute. The first bills that we're going to bring up today is Senate Bill 1103. Senator Moon is here. Perfect. Begin when ready.
Good morning, Mr. Chairman and committee. Thank you for allowing me to present Senate Bill 1103. My name is Mike Moon. I represent the Missouri 29th Senate District. And this bill has been presented before and nearly passed on at least one other occasion. What the bill does is allows a judge to issue a lifetime protection order for someone who has been a victim of a dangerous felony. The order is can be served, if this is passed, at the time of sentencing and remains in force until the offender either dies or the conviction is overturned or the victim files a written request to the court to terminate the order. There is a list of dangerous felonies. I'm not going to take time to read that because that's easily accessible. Unless you have a question, I'll skip that part of it. But this improves the current law by allowing a victim of a dangerous felony to get that lifetime protection order at the time of sentencing, so they don't have to go back and face their stalker or the one who perpetrated the crime against them a second or third or multiple times. It also allows a judge who knows the case and is familiar with it to take care of the sentencing right away, as opposed to having to go back and present your case again. It would save paperwork. Also, dockets are full enough. There's no sense in having to refile and consider the case again just for the lifetime order. It streamlines it, closes the safety gap, allows the victim to have some satisfaction that they are going to be protected without having to go back to the court system. There was a woman who testified for this bill in the past who told us her story, and she spent years going back and being traumatized because of the person who committed the crime against her. The judge, of all things, asked her in court, "What did you do to deserve to be raped?" As if she brought that on, and that's just horrendous. It's unconscionable that a judge would have that mentality to ask that question to someone who had been victimized like that. So the bottom line here is that 1103, Senate Bill 1103, guarantees that survivors of Missouri's most serious crimes receive seamless lifelong protection the moment justice is served. So if you have questions, I'll do my best to answer those. Otherwise, hopefully we can get this to the floor quickly and get it passed to protect victims.
Thank you, Senator. Senate Bill 1103, like you said, has been around, I want to say, the entire time I've been in the Senate. Yep. And I think probably even before then. Am I correct?
It may have been. I'm not familiar with who might have carried that, but it's likely.
And the language of the underlying bill, I know we've had it on the Senate floor several times. Is this fairly similar or identical to what you had last year?
Yes, it is.
Okay. Mm-hmm. Any questions for Senator Moon on Senate Bill 1103? Hearing none. Your first witness can come up in support. They will have 5 minutes. Any in favor? Seeing none. Any against Senate Bill 1103? Seeing none. Any for informational purposes? Seeing none. That will conclude the hearing on Senate Bill 1103.
Thank you.
Thank you, Senator. The next bills that we are going to hear together are Senate Bills 1164 by Senator Brattin and Senate Bill 1476 by Senator Nicola. You each will have 5 minutes to present. 3 minutes to present, my bad. If you want to start, go ahead. Proceed when ready.
Thank you, Mr. Chair and committee. Appreciate the opportunity to present Senate Bill 1476. For the record, I'm Senator Joe Nicola. I represent the 11th Senatorial District, which is the northeast corner of Jackson County. Senate Bill 1476, pretty straightforward bill. It says adult cabaret performances should not take place on public property. They should not take place in locations outside an adult cabaret where a minor is reasonably expected to see them. That prohibition is created in a new section 573.520 of the bill. What's really happening is that this bill puts a clear definition and a clear boundary into statute. It defines adult cabaret performance as a performance that appeals to a prurient interest and features topless dancers, go-go dancers, exotic dancers, strippers, male or female impersonators who provide entertainment or similar entertainers. That language is added into the affected statute in the bill. What my bill would do is simple. It would prohibit these performances on public property, prohibit them in other locations outside adult cabarets when they are reasonably expected to be viewed by someone who is not an adult. Set penalties at a Class A misdemeanor for a first offense and a Class E felony for a second or subsequent offenses. Preempt conflicting local ordinances under the terms laid out in the bill. Why this matters is also simple. Parents should not have to wonder whether adult-oriented performances are going to be taking place in public spaces or in settings where children can be exposed to them. This bill is about clear standards, protecting minors, and making sure adult entertainment stays in adult venues. I want to be plain about this. This is not about targeting everyday people. It is about setting reasonable guardrails where sexually explicit adult performances can happen and where they cannot. It gives the state a clear line in the law. And with that, I'd be happy to answer any questions and have my colleague present his.
Yeah, thank you.
Did you want to add, or go both at the same time? Okay. Thank you, Mr. Chairman. For the record, Senator Rick Brattin, 31st Senatorial District, bringing forth Senate Bill 1164, also dealing with the adult cabaret performances for children and banning that. It's unfortunate that we have to come here and actually sponsor bills like this to put a stop to these sorts of behaviors that deal with sexually explicit material and actions for children. And I'll go as far as say this is an attempt of grooming children into this sort of behavior and being okay and being off guard. And I'll read what the FBI consists and defines that as. Grooming is the deliberate process by which an adult builds an emotional, psychological, or physical connection with a child in order to lower the child's inhibitions, desensitize the child to sexual topics or contact, and create opportunities for sexual exploitation and abuse. And we've had these sort of unfortunate performances in my district, in Johnson County, in Warrensburg, and to think that people are dressing provocatively, dancing for children in this sort of manner, these sorts of dances, and I'll happily send the committee the types of dances and the types of performances that have gone on all over this nation of children stuffing dollar bills into the G-strings of these performers, very provocative, and you know, these sorts of actions absolutely are grooming of children and are completely out of bounds for allowance of this for children. If you want to be an adult and go to these sorts of performances, by all means, have fun. Good on you that you want to do that. But when we're talking children, we would never in a million years allow them to go to a strip club where women are taking off their clothes for men. We would never think that's appropriate. But now, all of a sudden, we think it's appropriate because we have men doing the same thing, same actions towards children, and because of the subject matter, all of a sudden it has to be okay. Now, prurient interest, let me read what that actually is, deals with pornographic material. That's the definition for minors, and obscene type of provocative action. So anything dealing with sexually provocative type material is what is being prohibited. It's not a potential performance of a man dressed as a woman and an actor in a play at a school. That's not what this inhibits. It has to do with sexual type behavior and performance to children. So this should be a cut and dry, I would hope, bipartisan type bill and approach to put a stop to this behavior. And I hope that's the case. Be happy to answer any questions before the committee. Thank you, Mr. Chairman.
Thank you both for presenting Senate Bills 1164 and 1476. I'm looking at some of the minor differences between the bills. Is it the intent of both of you to kind of combine these together and run them as one? Okay. The other question that I have, I know this came up last year in this hearing, is that we're going to ban all of these types of performances. That's not what this bill does, and I think you kind of eloquently stated it, Senator Brattin. If adults want to partake in these events, if these events want to continue to happen in the state of Missouri, they can, as long as children aren't present. What is some of the pushback that you've heard? Because I think it's fairly common sense that children shouldn't be at these types of performances that you've defined within this bill have prurient interest, which is all over our obscene material statutes, pornographic material statutes, abuse statutes, that is clearly defined in law. What reasons have you heard from the other side? And I know we'll probably hear some witnesses today, but I think this is fairly narrowly tailored to sexually fueled performances that kids are present at.
Well, I think from last year's testimony in opposition, the opposition felt that this was a constitutional right in order to do this to children, and it's their First Amendment right to be able to perform to whomever they wish and they choose. So that to me is problematic. You do not have a First Amendment right. The Supreme Court has ruled continually to obscenity and to perform obscenities, especially to minor children. So I do not believe that this in any way, shape, or form is an inhibiting factor to your constitutional right to shake your groove thing to people who you want to, but you're not going to do it to children in a provocative way, and that's where we need to step in.
Are there other areas of law, and I know you probably are well aware, other areas of law where we as the legislature over the years, whether it's Republican legislature, Democrat legislature, have banned certain instances of kids having access to things or performances or material?
Well, sure. I mean, I was a sponsor and was able to ban pornography in public libraries and content and comic books or whatever, any sort of literary content that has sexual nature and type of behaviors or whatever that's in literary form or even in 3D print. So to me, this is just even more common sense that we're going to have live action, performances. If we did it for literary or for visual in a print format, then why on earth would we think that it's okay in a live action format? So to me, this is just in line with what is already law in the state of Missouri.
I'm going to pause briefly so we can call the roll and get a quorum. Mr. Secretary, call the roll.
Senators Schroer.
Here.
Gregory 15.
No, that's fine.
Brown 26.
I have a lot more experience with this.
Berger.
I filed it last year.
May.
Right here, so.
Roberts. Schnelting.
Having a quorum, we're going to proceed on public hearings of 1164 and 1476. Any questions for the sponsors? Hearing none. Your first witnesses can come up, and please make sure that you all indicate on your witness form and in the public testimony if you are for or against 1164 and 1476. First witness in support, please come forward.
Good morning, Mr. Chairman, members of the committee. My name is Arnie C. A.C. Dinoff, State Public Advocate. I just wanted to make sure that you guys received my electronic format of my witness form that was submitted a few days ago. Cool. So when it comes to these two bills, I'd like to see them merged together. For one, in St. Charles County where I live, I don't know of this happening, but I'll tell you what, if my county, if the people in our county knew what was going on, I think that they would be having a conniption fit. I think that this legislator, government in general, has the obligation and the responsibility and accountability to hold people accountable of the state of certain morals, certain ethics, and certain protections for children. When it comes to nudity or dancing in front of children, showing body parts, like the sponsor said, I think that should be a decision made after 18 years of age. To subject children under the age of 18 is hypocritical, is, in my opinion, a violation of protecting that child, and is a hotlineable item to the Missouri Department of Social Services for proper investigation. If I saw any child giving money or putting money to somebody that was partially or fully nude, I would have a huge obligation to inform law enforcement and inform the Department of Social Services that there needs to be a full investigation conducted from top to bottom about why this is happening, why that child is being subjected to something like that. These are two good bills. As the bill sponsor said, I can't believe that in today's age that any parent would want to subject their child of a young age to that type of sexuality or nudity. I think it's just wrong parenting. It's the wrong way that our state is going, in my opinion, and I can't believe that we need this legislation to curb or stop this immoral, unethical, and I think it's a ludicrous type of public nudity or public dancing that's going on. That's my testimony, Mr. Chairman, and I'm in support of both bills.
Thank you, Mr. Dinoff. Any questions for Arnie? Seeing none. Moving to the first witness in opposition of 1476 and 1164. Make sure you state your name for the record, have a witness form, and begin when ready.
Good morning, committee members. My name is Chris Lehman. I'm a co-operator of Inclusion Plus. We're a drag production and Pride Fest organizer operating statewide. Let's start off with a topic that this committee, both bill sponsors, and I agree on. That's sales tax. According to KSDK News, Ozark First, the Missourian, and KSHB, over 400,000 citizens of Missouri and surrounding states attended major city pride festivals from June to October of 2025. This resulted in millions of revenue from vendors, city license fees, lodging, tourism, and gas, all having consumer taxation. Cities and regions of Missouri benefit economically and culturally from LGBTQ community art. The elimination of public drag shows by female and male impersonators will be culturally and educationally detrimental. Festivals, concerts, and ticketed events have a handful of similarities. A, the ticket and publicized info lead the patron to a pre-understanding. B, the art themes are tailored and screened for intended audiences. C, parental or familial consent and control leads to ultimate decision-making on attendance or lack thereof. Families aren't stumbling upon drag shows after crossing through metal detectors, police, security officers, and ticket booths. It's just not happening. The bill sponsors argue that by simply impersonating a male or female for entertainment purposes, the end result should be criminality. This is wrongful overreach and subjective language intended to unfairly target and attack LGBTQ Missourians, the arts community, commerce, and parental decision-making. The costuming, singing, storytelling, and art that's happening at pride festivals and all ages accepting drag shows is completely appropriate for public view because we already have state laws covering decency, appropriateness, behavioral vulgarity, and harassment. Merely dressing in outlandish clothing, colorful costumery, and accessories that match or do not match one's perceived gender should never be regulated. If we turn to the lack of fiscal notes provided, unknowns are present around administrative costs for the implementation of Class A and E offenses. How and to what stipulation Would local police have decision-making, and how do the tactics of preemption against city and county ordinances fiscally affect the aforementioned? The expenditure only mentions incarceration costs at 1 to 3 persons per year. There's nothing for administrative funds or training funds. The class action mentions on page 3 of Bill 1164, lines 52 to 57, are never noted again. These bills are poorly written, and once again, will have more negative impact across Missouri than only harming the LGBT community and arts communities. Miller v. California, 1973, established reasonable standards considerations. Number 1, prurient interests. The work, taken as a whole, appeals to a shameful or excessive interest in sex. By adding female or male impersonation as new sections, there's an unreasonable standard and subjective interpretation of clothing expression and artistic expression. I'm failing to understand how community standards applying to an automatic prurient interest could ever be applied to, let's say, the 2025 St. Charles Pride Fest, where they collaborated with Treats Unleashed Pet Supply to showcase a doggy drag show for adoption awareness. Prurient interests would be found where? Number 2, patently, the work depicts sexual conduct in a clearly offensive way, as defined by law, not just mildly subjective or controversial. We already have state and federal laws that subject lewd behavior. Ultimately, this is my 4th year testifying against these anti-drag and performance art bills that have unforeseen and unquantifiable negative impacts towards the state of Missouri. These bills harm well beyond less than the 10% of Missouri families who are LGBTQ+ and who actually attend these festivals. We're already seeing tax-paying businesses, first-time homebuyers who are fleeing. Students are transferring elsewhere. Collegiate programs are being shut down due to low enrollment, all because of divisive and controlling bills like these two. Vote down these bills that harm identity and expression, allow financial constraints and overreach. Thank you. I'd love to answer any questions.
Right on time. Thank you for your testimony. The first question I have before turning it over to the committee, you mentioned parental consent. You believe that parental consent should be a vital part of allowing kids into these types of performances that are written in these 2 bills, correct?
Correct.
So let me just start there. We're defining what these types of performances, which should be outlawed, are appealing to prurient interests, characterized by fixate on, depict, exhibit sex, sexually explicit content, sexual desire, a state of nudity or a state of semi-nudity, or obscene or pornographic material. You believe that kids should still be allowed to view that?
No.
So which one is it? Because I think that the 2 bills have kind of clarified that not all drag performances would be classified here. Not all Pride Fests would be criminalized under this. And I think you stated, and I don't want to misquote you, that one of the bill sponsors stated impersonating a female or the opposite sex should be criminalized. Which bill sponsor stated that? Because I didn't hear that today.
Well, that would be, if we look at Bill 1164, top of page 2, it automatically lumps male or female impersonator into all of the mentioned above, bottom of page 1, top of page 2.
That's under the definition of adult cabaret performer, but in order to be classified as one of these types of performances, you have to look at the other definitions as well. So you have the adult cabaret establishment, the performance, the performer, but then when you look at the prurient interest and actions or materials that appeal to that, that's where I mentioned the characterized by, fixate on, depict, exhibit sex, sexually explicit content, sexual desire, state of nudity, semi-nudity, or obscene or pornographic material. And it's your testimony today that not all of the performances that you all partake in or host are classified under that actions or materials that appeal to prurient interest in sex, correct?
Yeah.
So I think for the body's sake, I think we need to separate both of those. And I think that's what these bills are trying to do. And I think all of the witnesses that we've heard previously and the bill sponsors have said, if you want to continue having these performances, that's fine. But once you cross the line of, as the definition states, showing or appealing to a prurient interest in sex, that's where kids should not be allowed. And I don't want to misspeak. I think the bill sponsors have kind of eloquently stated that.
But
Is
if
it-
we're
Go
sorry,
ahead.
But if we're talking about simply male or female impersonation on public property, top of page 2, bottom of page 2, the language is so broad that you're grouping in.
That's just a definition
Persons.
of a certain type of performer. But looking at the definition of the actions, that's where I want to clarify, because I have no patience for even a parental consent allowing for a kid to view porn or buy cigarettes or
Correct.
or purchase alcohol. I think we as a legislature, we as a society have deemed certain areas of law where, yes, we're going to draw the line and say kids shouldn't be exposed to this. Kids, even if parents allow them to do it, we're going to draw the line and say that should be criminalized. I think we found a little bit of common ground that you would probably say even if a parent agrees to allow a kid into a strip club, that shouldn't be allowed, correct?
Correct.
So what is it within the bills, outside of the definitions, when you look at the certain types of actions that we're trying to prohibit? What in the bill are you having an issue with? Because I don't see in both of the bills where it's prohibiting drag shows that aren't appealing to a prurient interest in sex.
Because it's automatically lumping in that the fact that male and female impersonation is automatically inherently sexualized.
I'm not following you, but with that, I'll open it up to any other questions. Any other questions? All right, thank you for your testimony today. Going back to those in support of Senate Bills 1164 or 1476, please come forward. State your name for the record, have your witness form, and begin when ready.
Lisa Panett with Armorvine, and it's just sad that we have to bring these kind of bills and pass these kind of bills to protect our kids. That's it.
Any questions? Seeing none. Next witness in opposition of the Senate bills, please come forward, state your name for the record, and again clarify which of these bills, one, the other, or both, you were in opposition of.
Good morning. My name is Samantha Jones, and I'm a lifelong Missourian, a taxpayer, and a community theater volunteer, and I am a priestess. And I am against SB 1476 and SB 1164. These bills are extremely similar to bills written in previous years, and this is a blatant attempt to waste time and money and attack the LGBTQIA+ community, and specifically the trans, drag, and intersex community. The language of these bills is vague, defining any instance of cross-dressing as adult cabaret. In Missouri, children already cannot attend any adult performances such as burlesque, drag shows, and bars, and the like. The law is unnecessary. We have a First Amendment right to wear the clothes that we would like to wear as a protected form of self-expression in public, as long as our genitals are not exposed. Many cities have public indecency laws, as do the state and federal levels, and wearing clothing that one feels comfortable in is not at all breaking these laws and shouldn't be considered a criminal offense. Today I am wearing a suit. It would be considered cross-dressing. Defining people wearing the clothing of the opposite sex in public is difficult to determine and enforce. This not only affects everyday people in their everyday clothing, this also affects theatrical performances. Shakespeare, Aristophanes, J.M. Barrie, and many other playwrights that have characters and plots based on mistaken identity through characters wearing clothing of the opposite gender. Peter Pan, the character, is often performed by a woman. Community theaters, high school performers, college performances that do these plays, are they now going to be arrested for wearing the costumes and be considered sex offenders? Because this bill says that this type of performance is automatically sexual. Theaters, drag performers, and other performances bring a great deal of money to Missouri and to the towns that they occur. People go out to dinner before seeing a performance, keeping the local restaurants in business. Bars that have these performances keep brewers and farmers in business. Criminalizing these performances will reduce the overall revenue and reduce tourism, as people traveling will not be allowed to wear their clothing without fear. This is intimidation, discrimination, and harmful to all Missourians. Our First Amendment rights should not be curtailed, and vote no on these bills.
I know you indicated that and we've heard it a couple times, Peter Pan, the lady who portrayed Peter Pan, Mary Martin, I believe, and several other women who have been known to portray or act as her. that that's somehow sexualized under this bill?
Yes,
Can you
because-
point to me where in either of these bills that it's sexualized?
The gentleman before me explained this to you
Can
already.
you point to that?
But it is in
Because-
1164.
Excuse me, my question. My question to you is where in these bills, not from other witnesses, where in these bills does it state that any type of individual who's acting as and dressing as another sex is somehow sexualized, as long as it doesn't meet the other definition?
Because this bill is so broad, and in 1164 specifically, where it is defining cross-dressing and people who are male or female impersonators, that the clothing
So let's
that they
take
are
that.
wearing
On
is
page
sexual.
1, on section 4, adult cabaret performer. An entertainer who has provided an adult cabaret performance, including, but not limited to, a topless dancer, go-go dancer, exotic dancer, stripper, a male or female impersonator. That doesn't automatically mean that the male or female impersonator is somehow sexualizing and having actions or materials showing to kids appealing to a prurient interest in sex. I think when you look at statutory construction and statutory interpretation, that would not apply to Peter Pan or any other cross-dresser, as long as they're not exposing themselves or showing certain materials that are fixating on, depicting, exhibiting sex, sexually explicit materials, sexual desires, or a state of nudity or semi-nudity.
And unfortunately, that bill language is extremely vague. When you're talking about cross-dressing here, when you're talking about what we're wearing, you are implying that the clothing that we are wearing when we are wearing opposite clothing wearing clothing that is of the opposite gender, that it is inherently sexual. Wearing clothing is not inherently sexual. Dancing is not inherently sexual. Performing in clothing of the opposite sex is not inherently sexual.
And I think
that
this
is
bill
what these bills
clearly
are
states
saying.
that. This bill clearly states that because there is a certain definition, actions or materials that appeal to a prurient interest in sex, which is defined, and I'll state it again, and I'll state it 15 other times in this committee, actions or materials that are characterized by, fixate on, depict, exhibit sex, sexually explicit content, sexual desire, a state of nudity or semi-nudity, or obscene or pornographic material. That's the qualifier that will make any of these performances criminalized under this bill if it's exposing to minors.
And how would you define a performance in Shakespeare where somebody is wearing a dress and they are dancing? Would you consider that
Not
sexually
sexualized
explicit?
under this bill. Not criminalized
Even if they're
under
dancing
this
in a sexual manner, and
Not
it's, say, for
criminalized under this
example,
bill.
a musical?
Not criminalized under this bill.
It seems to be because the language is so vague.
So let me just state on I'm going to ask you the same question as I asked the last witness, or two witnesses ago. On that definitions of actions or materials that appeal to a prurient interest in sex, is it your belief that kids should be allowed to be exposed to this?
No, they're already not exposed to this. We already have laws that prevent
Let me
them from
finish the
entering
question.
these spaces.
Are you of the position that kids should be allowed to be exposed to actions or materials that appeal to a prurient interest in sex as defined by this bill, as long as parents consent to it?
Sir, I think
Yes or
you're
no?
trying
Just
to
very-
twist my
very simple.
point. And no, children should not be exposed to sex.
Okay. Any further questions? Senator May.
Thank you.
I don't agree with my colleague, as you can tell.
Indeed.
That's right. So basically, I agree with you, and this bill is definitely broad. And if I look at 1164, first of all, if I look at lines 25 through 30, this describes every teenage young girl that I see walking around today with short shorts on and low tops and half shirts with half moons coming from under the bottom of them. So,
Yes.
I mean, this right here describes that at this point.
Yes.
So, when we're talking about, and then when you are performing or dancing or whatever, where do we draw the line? Who is to determine if I'm dancing, if it's sexual or not sexual?
Exactly.
That's the key. And, who is to say if my V-neck shirt or my half shirt is, explicit or nothing? And I believe that parents have the right to determine what their children do and not anybody else. Because to
Agreed.
me, you're getting into parental rights in that point. So, at this point, I do think the bill is a little broad and it needs to be tightened if we're talking about protecting children. But I think that most of the places where they do the cabarets and things like that where I'm at, are basically bars and are 21 and over. So kids are not in there in the first place.
Yes.
And people should have a right to express themselves in the clothing that they wear, and we shouldn't, judge people based on what they wear.
Yes,
So-
exactly.
I'm in agreement that the bill is broad and it needs some attention. And I definitely agree in protecting kids from explicit sexual grooming, but I think this goes a little broader and beyond that.
Yes, it does.
So, thank you for your testimony.
Any further
Thank you.
questions? Seeing none. We're now going to take a brief pause and go to an executive session. I know certain members have other committees to go to. So I now move that we go into executive session. Do I have a second? Having a second, we are now in executive session. I now move that we bring Senate Bill 1458 before the committee. Do I have a second? Having a second, Senate Bill 1458 is now before the committee. This is the bill presented last week or 2 weeks ago by myself on felony apprehensions and fingerprinting and DNA samples being collected. Are there any questions? Hearing none, I now move that we vote do pass Senate Bill 1458 out of committee. Do I have a second?
Second.
Having a second, Mr. Secretary, call the roll.
Senators Schroer,
Aye.
Gregory 15, Brown 26, Berger, May,
No.
Roberts, Schnelting.
By your vote of 4-1, the motion passes. I now move that we bring up Senate Bill 1531. Do I have a second?
Second.
Having a second, all those in favor, I'm getting ahead of myself here. Senate Bill 1531 is now before the committee. I do have a substitute which was distributed 2 weeks ago, and that's what we presented on. I know, let me see. Yeah, everybody should have a copy of that from a couple weeks ago. Yeah, I now make a motion that we adopt the Senate committee substitute that we presented on a couple weeks ago. Do I have a second? Having a second, all those in favor signify by saying aye. Aye. All those opposed say no. And the ayes have it. Senate Bill 1531 is now on the Senate substitute, and that was the one that we modified on temporary custody or visitation orders for children with special needs and making some tweaks to guardian ad litem status. Have any questions?
Yeah, so is that the difference between the sub and the substitute?
Correct. We trimmed it down greatly and zeroed in on temporary custody orders and making motions to modify those for children that have special needs and guardian ad litems and qualifications that they would have to have in those instances to make sure that certain kids that may not be verbal, that the guardian ad litem will at least have training in specializations on how to communicate with those kids.
Yeah.
Any further questions?
Vote yes right now.
Seeing no further questions, I now move to adopt the Senate committee substitute for Senate Bill 1531. All those in favor signify by saying aye. Aye. All those opposed say no. You guys have it. Senate committee substitute has been adopted. I move do pass Senate committee substitute for Senate Bill 1531. Do I have a second? And some good music too. Mr. Secretary, call the roll.
Senators Schroer,
Aye.
Gregory 15, Brown 26, Berger, May,
Aye.
Roberts, Schnelting.
By a vote of 5-0, motion passes. I now move that we bring up Senate Bill 854 from Senator Brian Williams on clean slate. Do I have a second?
Second.
Having a second, the bill is now before the committee. I'm going to merge these. We've got a Senate committee substitute, 854, and Senate Bills 1494. Just combining those together and mirroring the House version that passed. I've got a, let me see. Yeah, so we merged those two bills together with Senator Brian Williams' number being the handler. Any questions on that? On the Senate committee substitute?
Which one we on?
This is Senate Bills 854 and 1494 on clean slate. Seeing no questions, I now move to adopt the Senate committee substitute merging Senate Bills 854 and 1494. Do I have a second?
Second.
Having a second, all those in favor signify by saying aye. Aye. All those opposed say no, and the ayes have it. The Senate committee substitute has been adopted. I now move that we do pass Senate committee substitute for Senate Bills 854 and 1494. Do I have a second? Having a second, Mr. Secretary, call the roll.
Senators Schroer,
Aye.
Gregory 15, Brown 26, Berger, May,
Aye.
Roberts, Schnelting. 5-0.
By a vote of 5-0, the motion passes. I now move that we bring up Senate Bill 1150 before the committee. Do I have a second? Having a second, we are now on Senate Bill 1150. This is Senator Berger's bill on mask intimidation, and I have a Senate committee substitute. Senate committee substitute is going to merge Senator Berger's 1150 and Senator Washington's Senate Bill 1043. Senator, do you wish to explain any of the changes? I think you just simply merged them. You're protecting law enforcement. This is the masked intimidation one, protecting law enforcement to make sure that this isn't applying to law enforcement having to conceal their identity. Any discussion on the Senate committee substitute? I now move to adopt the Senate committee substitute for Senate Bills 1150 and 1043. Do I have a second? Having a second, all those in favor signify by saying aye. Aye. All those opposed say no. The ayes have it. Senate committee substitute has been adopted. I now move to pass Senate committee substitute for Senate Bills 1150 with great music again and Senate Bill 1043. Do I have a second? Having a second, Mr. Secretary, call the roll.
Senators Schroer,
Aye.
Gregory 15, Brown 26, Berger, May,
Aye.
Roberts, Schnelting. 5-0.
By your vote of 5-0, motion carries. And I move that we bring up Senate Bill 1135 on Bentley's Law. This is Senator Henderson's bill. Do I have a second? Having a second, the bill is now before the committee. Is there any discussion on Senate Bill 1135? This is Bentley's Law that has been in this committee several years, I think dating back to 2022. Hearing none, I now move that we vote do pass Senate Bill 1135. Do I have a second? Having a second, call the roll.
Senators Schroer,
Aye.
Gregory 15, Brown 26, Berger, May,
Aye.
Roberts, Schnelting. 5-0.
By your vote of 5-0, motion carries. Last bill, before we get back to the public hearings, I now move that we bring up House Bill 1644. Do I have a second? Having a second, we are now on House Bill 1644. This is the joint employer bill that we've had for several years. I do have a substitute which exempts Major League Baseball in this as well. I know there are a lot of discussions with Major League Baseball. I believe you've been spoken with by several members on why this is important.
What bill are we on?
I'm sorry, House Bill 1644.
House bill or Senate bill?
House Bill 1644, the employer-employee relationship by Representative Overcast.
Okay. We were so busy.
Any further questions on,
Yeah, give me that.
any further discussion on the committee sub? I now move that we adopt the Senate committee substitute for House Bill 1644. Do I have a second?
Oh, yeah, I know what this is. Thank you.
Having a second. Do we have a second? Going once? Having a second. All those in favor signify by saying aye. Aye. All those opposed say no. The ayes have it. The Senate committee substitute for House Bill 1644 is adopted. I do agree with you, Senator May. I now move that we do pass Senate committee substitute for House Bill 1644. Do I have a second? Having a second, Mr. Secretary, call a roll.
Senators Schroer,
Aye.
Gregory 15, Brown 26, Berger, May, Roberts, Schnelting. 5-0.
By your vote of 5-0, motion carries. I now move that we exit executive session and go back to the hearings on Senate Bills 1164. All right, we're now back on the Senate Bills 1164 and 1476. The next witness in support, please come forward. You will have 3 minutes.
Good morning, committee. Thanks for the hearing. My name is Mike Compton with Act for Missouri, and I just want to go on record in support of this bill. It's a common sense child protection bill that we definitely need.
Thank you, sir. Are you supportive of both of these bills?
Both, yes.
Okay, thank you. Any questions? Seeing none. Now moving back to those in opposition of the Senate bills, make sure that you state your name for the record and which bills you're against, and make sure you have a witness form. Proceed when ready.
Good morning. My name is David Lee Brush. I'm with the Missouri Equity Education Partnership, and we oppose this bill. I I have 50 years in theater experience, and 24 of it as a theater educator, 20 of it in community theater, 2 of which was an executive director of a relatively large community theater enterprise in mid-Missouri. And this bill is concerning because I know the feeling is that it's not going to curtail shows like Peter Pan and all that, but the language is broad. Male and female impersonation is very broadly stated. It is not defined well, and as a theater educator, one thing that I know is that in educational theater, we don't have a lot of boys try out for shows, so sometimes we have to put a girl in a boy's role, and we can either gender swap the role and turn the role into a girl's role, or we can dress her as a boy and have her play Professor Plum and Clue. Also, community theaters have some of the same problem. I saw a lovely production this summer of 1776, where John Hancock, Richard Henry Lee, and Thomas Jefferson were played by women, and they were dressed as men to do so because they didn't have enough men try out for the show. What I'm afraid of is because female and male impersonation is vaguely defined, and prurient interest, the part where it says sexual desire, that is a very personal choice. So what is, and I don't need to know anybody's choices, but what's sexually desirable to one person might not be to another. 10 to 20% of the population of the United States, adult population, identify as having a sexual attraction to feet. So does that mean that we can't do Cinderella? Because that could have a prurient interest to somebody in the audience. This bill is very, very broad. And my concern as an educator is that it is going to have an absolute chilling effect on school districts, like the amendment did to ban the books that were deemed quote-unquote pornographic. While the statute was relatively clear, school districts were terrified that they were going to accidentally put something out there, so they quietly unshelved a lot of books. So as an educator, I'm sitting here thinking, how is this bill going to play out in schools all over our state? Our district's going to say, oh no, I don't really want you to do Peter Pan because that has a girl playing a boy's role, which, by the way, that's called cherubini. That is an adult female playing a child male, and that comes right out of Baroque opera, because drag is as old as theater, and it crosses cultures, it crosses time, it crosses continents. It is a legitimate, exquisite form of art. And just like not all dancers go to strip clubs and do exotic shows, so dance should not be banned, not all drag is the same way. And I know that the intention is supposedly to not ban all drag, but the underpinnings of this bill clearly show, and past bills have, said that drag is inherently, innately sexual, and it is absolutely not.
Your time has expired.
So
I'll
sorry.
give you a couple
Thank
seconds
you.
to wrap up.
Thank you. Theater is really important to a lot of kids. Like many kids find not just a life in theater, but a way to express themselves and feel comfortable and find a core family of people. But it also is educational. It touches all core activities: math, science, social studies, and history. It
All right.
is
Any further
reason-
testimony
no.
you can submit
No.
in writing?
It's in writing. Thank you
All
so
right.
much.
Do y'all have any questions? Seeing none. Thank you for your testimony. We're going to move back to those in support of Senate Bill 1164, 1476. Last call for those in support of Senate Bills 1164 and 1476. Moving on to those in opposition. Please come forward, state your name for the record. And we're going to move to 1 minute, as we only have about 40 minutes left and 3 more bills to get to.
Absolutely. Hi, I'm Stevie Miller from West Plains, Missouri. I'm a non-binary trans man and drag performer, and I'm here today in drag urging you to vote against these. Don't even pass them. I have been part of producing, hosting, and performing several public drag shows this last year. I'm going to do more of them. I want to go ahead and state that there are already statutes in our law, Chapter 573, and there are other that are already in place. I've spoken against a local drag ban as well as attended city council about those very definitions. The laws hold fine. Our local law enforcement has seen our public shows and said nothing against these is broken, but also because we're not creeps. We spread love and joy. But also, As a trans man, in the eyes of someone who doesn't see me for who I am, they could easily define me as a male impersonator. And furthermore, in drag here, you're not sure what's going on. There's those that find me a walking sexual perversion as I am right here and now. And like, I can't help it if somebody finds me sexy, body T. People call me a pervert in my normal t-shirt and jeans.
Your time has expired. Any questions? Seeing none. Thank you for your testimony today. Next, in opposition of Senate Bills 1164 and 1476. Last call for those in opposition to Senate Bills 1164 and 1476. Make sure you state your name for the record, which bills you're opposed to, and you'll have 1 minute.
Good morning. Jonathan Schmidt, representing the American Civil Liberties Union of Missouri. We stand in opposition to these bills. We believe that they are unconstitutionally overbroad and vague and infringe on constitutionally protected speech.
Thank you for your testimony. Any questions? Seeing none. Next, in opposition to Senate Bills 1164 and 1476. Please come forward, state your name for the record. You'll have 1 minute.
Hi, my name is Cammy Storm. I live in West Plains. I'm here in opposition to both of these bills. When I read SB 1164 and 1476 together, I don't see two separate bills. I see a system being built. 1476 expands definitions on what counts as adult cabaret performance, where it can happen, and who can be charged. It uses broad, vague language like performances that could be seen by a minor, and it attaches criminal penalties that escalate to felonies. 1164 then adds another layer allowing civil actions and enforcement mechanisms that go beyond criminal law and defines one defines, one enforces, and together they create a structure that can be applied far beyond what is being claimed in this room. When I compare this language to bills in other states, I see the same structure, the same phrasing, the same legal strategy. Adult cabaret performances, Puritan entrance, could be viewed by minors. These are not unique to Missouri. They are part of a broader legislative pattern being introduced across the country. SB 1476 itself acknowledges that this bill language is not new. It repeats prior bills.
Your time has expired. Are there any questions? Seeing none, thank you for your testimony.
Thank you.
Next, in opposition to Senate Bills 1164 and 1476.
Hello, my name is Dean Anderson. I'm from Columbia, Missouri. I'm in opposition to 1476 and 1164. I have a master's in education, and when I hear these bills, I also am confused about where drag falls. I think it's purposefully vague. Drag is art. Flip Wilson, Tootsie, Doubtfire, Medina, even Bugs Bunny and Daffy Duck did drag. It's an art form, and it should be protected under the First Amendment. And vilifying art forms for political gain is despicable, and it's un-American. You should be ashamed. We're looking at an oath. You took an oath to uphold the Constitution, not to trample it. And I'm here to say that I stand up for the Constitution of the United States and the people's right to express their beliefs and in art forms, even if other people do not find it necessarily appreciable. Thank you.
Thank you for your testimony. Sir, you might have some questions. I will just state I'm not ashamed of having these bills before us to try and find a way to protect kids from being exposed to sexualized material.
I'm ashamed of a state that's trying to trample our Constitution.
Okay. Any questions? Seeing none. Next in opposition, please come forward, state your name for the record. Seeing none. Any for informational purposes on Senate Bills 1164 and 1476? Seeing none, that will conclude the public hearings on Senate Bills 1164 and 1476, and we're going to move to House bills with probably the senior member, Representative Black. Please come forward on House Committee Sub House Bills 2637 and 3155.
Thank you very much, Mr. Chair, members of the committee. John Black, House District 129, Webster County, Missouri. Thank you for allowing me to present House Bills 2637 and 3155, sponsored by Representative Cook. Members of the committee, probably aware, this is the House version of the Transparency, Truth in Sentencing Bill that was included in Senate Bill 888. This bill is effectively the equivalent of Senate Bill 882 that was sponsored by Senator Trent, which was included in SB 888. That bill has been TAFP'd. I believe this bill might provide a vehicle, Mr. Chair, for any necessary technical corrections that existed in Senate Bill 888. Happy to answer any questions.
Any questions for Representative Black? I almost called you Senator. Maybe in the future. Representative, or Senator. You got me confused up here.
Hello, Representative.
Hi,
How
Senator.
are you?
I'm fine, Senator. How are you?
So is this bill identical to 888?
Pardon me, ma'am?
Is this identical to 888?
It's identical to the Senate bill sponsored by Senator Trent that was included in 888 with modifications that existed to combine that bill with the juvenile bill, ma'am.
Okay. I just want to look that up. Do you know what that Senate bill that Representative
Trent had 882, I think, ma'am.
his was what?
His was 882.
882. Okay, very good.
And Representative, for the record, it's your intent to kind of marry that language that we had in 888 that is going to the governor's desk.
As would be approved by the Senate, of course, Senator, yes, I would think that the language of 882 and the juvenile bill that became 888 would be combined again to provide a vehicle for any technical corrections that are necessary.
I appreciate it. Any further questions? Seeing none, your first witness can come forward on House Committee sub for House Bill 2637 and 3155.
Morning, Mr. Chairman, members of the committee. For the record, Trevor Foley, Director, Missouri Department of Corrections, to testify in support of House Bills 2637 and 3155. As Representative Black stated, I assume the mission would be to mirror what passed on the transparency side with 888 and use it as a vehicle for any necessary technical corrections.
Any further questions? Senator May.
So do you see any technical questions? I mean, we negotiated for 15 hours.
I have had, it has been brought to my attention that there could be some word changes necessary in 558011, just where the word offense was used that should state conviction. I believe my legal is looking at that as well. I haven't heard of any others, but that was the one that I'm aware of.
Okay, thank you.
Any further questions? Seeing none. Thank you, Director. Next, witness in support of 2637 and 3155.
Thank you, Mr. Chairman, members of the committee. My name is Arnie C. AC Dinos, State Public Advocate. I submitted my online testimony in the portal, the Senate Witness Portal. I testified back in January 20th, and I talked about a lot of issues there. The first issue is I talked to a lot of judges, and I know how the judicial system works. I go to some court cases that are high-profile cases, and everybody is on the same page that there needs to be a truth in sentencing. I know judges that they sentence somebody to a felony crime and send them 15 years to the state penitentiary, and within a 2-year period or less are back in front of them for that same felony crime or another more severe crime. And that judge shakes their head because they sent them to 15 years to the state penitentiary, and now they're back before them with that same crime or a more severe crime. I think it's only pertinent, as I testified in the House Judiciary Committee, that when there's a trial, either held by a bench trial of the judge or a jury trial of somebody's peers, that when sentencing happens after a pre-sentencing investigation and that 30 to 60-day window goes by, that everybody in that courtroom, including victims, including the judge, the court staff, everybody involved in the process, parole and probation, know exactly what the sentence is being handed down. This HCS SB2637 and 3155 puts out those definitions of from a Class A to a Class E felony, and it tells you exactly the percentage that must be served. I think that Missourians are sick and tired of the same crime, and I know law enforcement definitely is sick and tired, seeing the same characters, the same criminals committing the same crimes over and over and over, because our judicial system, because the Department of Corrections and the Department of Probation and Parole are too lenient and don't give people consequences, responsibility, and hold them accountable for the crimes that they committed. I could go on. This is very important to me, especially when it comes to the dangerous felonies, when it comes to sex crimes, when it comes to rape, when it comes to robbery of people, jeopardizing their life and interrupting the life of families. There's a lot of victims that go to court and they don't know when they leave court exactly what the sentencing is. They don't know because the judge said 15 years if that person's going to be out in 2 or 3 years. And so for those reasons, I not only support HCS HB2637, 3155, as I also supported the all-encompassing Senate Bill 888. I'd like to see them all come together. We really need to do something as a state society, as a state citizenry, and we need to hold the courts, hold people who commit these heinous crimes responsible, accountable, and they need to do their time. Thank you, Mr. Chairman.
Thank you, Arnie. Only question I have, I know the previous bill was on your top 10. Does this make your top 10 also? Arnie's top 10.
Yeah, I mean, these are mirrored legislation, and so it would go with the Senate Bill 888. Something needs to be done. I know the fiscal note is way up there. I think it's $700 million. That's very concerning. We need to figure out ways to do that, but we need to hold juveniles and adults. We need to make sure that if they're going to commit the crime, that they learn their lesson the first time and they don't commit it a second time.
Any further questions? Seeing none. Thank you for your testimony.
Thank you.
And I did 2 in support. First one in opposition. Please come forward.
Mr. Chairman, members of the committee, Brian Burnskitter here on behalf of the Missouri Association of Criminal Defense Lawyers. A lot of this conversation that we wanted to have with you all is a little bit water under the bridge concerning the passage of 888, but we do have some serious concerns about the fiscal note and the possibility that this cost could be greatly expanded beyond what was estimated. The fiscal note estimates that the cost of keeping an offender per day is $30.47. According to our research, the full cost was closer to $99.90 a day. That's a pretty significant increase over that cost of what is estimated, and we're really concerned about the fiscal note as well. So happy to answer any questions.
Any questions? Seeing none. Thank you for your testimony.
Thank you.
Going back to those in favor. Seeing none. Any more in opposition? Seeing none. Yep. Please come forward.
Mr. Chair, members of the committee, my name is Ron Berry. I'm a registered lobbyist here today on behalf of Forward.us, and we just want to express our concern of a couple of things. We're afraid that this may actually increase some of the terms some of these individuals may have to serve, and then we also are very concerned about the cost as we go forward.
And you say Ford?
As we go forward, yeah, Ford.
Ford Motor Company.
Forward.
Oh, Forward, okay.
It's actually FWD.us.
Okay.
Same as their website.
Any questions? Seeing none. Thank you for your testimony. Any more in opposition for 2637 and 3155? Seeing none. Any for informational purposes?
Lisa Panett with Armorvine, and I didn't know whether to go on support or for informational purposes only. The reason why is the portion that we were concerned about with the dangerous felony is actually corrected in this bill. So that's why we prefer this bill, because we want to make sure that no one gets put under a dangerous felony because they refuse to vaccinate a child or have a medical procedure, and that was corrected in this bill. And so we would appreciate using this version versus the other version, because you're making 85% of a mandatory sentence under this, and that's the same as sex trafficking, forced labor. So that's a big deal that you're attempting to do right now, and so we very much prefer this version.
Ms. Bennett, I think we beat this with a dead horse, that with statutory interpretation and looking at the criminal law, the actus reus and mens rea, nothing was changed. Nothing was changed in the underlying...
Except for the dangerous felony part.
That's on the sentencing portion. Nothing was changed, and we've heard from the Attorney General's office, we've heard from prosecutors, we've heard from judges, we've heard from practicing attorneys that are saying, even if they wanted to utilize that in any way to prosecute someone for not vaccinating their kids, it could never happen.
It said solely for that
Again,
purpose alone.
when you look at the mens rea,
they haven't done it
when
solely yet.
When you look at the mens rea and the actus reus, that is not going to ever occur. Okay,
They could. They didn't
it's
say they
never
couldn't.
going to happen. And again, this is more
You
fake
couldn't
news.
say that could never happen.
Yes, I can say that.
No, you
As a
can't.
practicing attorney who has spoken to other attorneys
And so have I.
and the bench.
And so have I.
I appreciate your testimony. Any questions?
This-
Senator May.
Can you point out to me where you're talking about in the bill?
Yeah, well, it's corrected actually in this bill,
So
but
where is it at in the bill?
and so in 888, what it refers to is it's endangering the welfare of a child, and unfortunately, it's not in this bill because we pointed it out in the House and they took it out. So it wouldn't get swept up, but for some reason the Senate wouldn't change it over here. And I don't understand why, because everyone seemed agreeable to the change, but it's endangering the welfare of a child, which is under 568.045. And what that says is that in 568.045, it knowingly acts in a manner that creates a substantial risk to the life, body, or health of a child less than 17. And so what this is doing is sentencing, and it's requiring 85% of a mandatory sentence, and that is absolutely the same category as slavery, as forced labor, as sex trafficking. So if you were to violate that provision because you didn't have a medical procedure or a vaccination, and what the prosecutors put out in a letter was that no one has been prosecuted under this solely, meaning alone, for that, and they didn't foresee that changing. But the legalese in there are that it could take place, and we just want to make sure that we're shutting the door to that. We don't want to see good people get caught up in an unintended consequence.
Thank you.
Yes.
Any further questions? Seeing none.
Thank you.
Any more for informational purposes on 2637 and 3155? Seeing none, that'll conclude the public hearing on House Committee Sub for House Bills 2637 and 3155. Now moving to House Committee Sub for House Bill 2587 by Representative Jones.
Thank you, Mr. Chair, members of the committee. For the record, my name is Mike Jones. I represent House District 12. I'll be brief. I know it's been a long morning, and I know the chair is familiar with the legislation. This bill addresses the new and very real threat posed by unmanned aircraft around large public gatherings and critical infrastructure. Drones are no longer toys, as we all know. They are increasingly used for surveillance, smuggling, and weaponization. With Missouri set to host 6 FIFA World Cup matches and welcome thousands of visitors around the world, it's critical we have the tools in place to protect public safety. This bill gives trained and authorized law enforcement officers clear legal authority to detect, track, and respond to dangerous drone activity, and aligns Missouri law with existing federal authority. To keep Missourians safe at major events and everyday public spaces, our laws must reflect today's threats, and this bill moves us in that direction. And with that, I'll take questions.
Thank you, Representative. I believe the bill we passed yesterday, perfected, is identical except for in one aspect. I think, did you all make the changes on the commercial, Walmart, Amazon, any of the, okay, I'm hearing no. And I would assume you'd be okay with us providing that piece in there. Okay.
Absolutely, yeah, we can marry the two.
Absolutely. Any questions? Seeing none, your first witness can come forward in support of 2587.
Good morning, Mr. Chair, members of the committee. Alex Vivas, Chief of Staff, Missouri State Highway Patrol, Department of Public Safety, going on the record in support of this legislation, simply giving law enforcement the ability to mitigate drones if they're being used as a threat to public safety and or in the commission of a crime. Again, just want to go in support. Take any questions.
Senator May.
So, good morning. How are you?
Good morning, Senator. Good.
Help me understand the, when you say, how do we identify the threat to public safety? Because I know that we have events with large crowds and people, fly the drones and they take pictures of the, of the event and things from the drone.
Sure.
So how do we identify if it's a threat to public safety?
Sure, that's a great question. I'll give you an example. So for FIFA, for the World Cup event, there'll be, just like we use, the FAA uses with aircraft, and again, this aligns with FAA Safer Skies Act that was passed in December of 25 in December. And so there will be a list of allowed drone airspace, and we have, just like with aircraft, a tail number, they have a serial number that are assigned to those drones, and we'll maintain a list to know what drones are authorized to be in that airspace and what are not. And so if, and just like with an aircraft, if one of them enters an airspace that is controlled and is not allowed, they'll be warned, and once they're warned, if they do not comply, they can either be sent back home with an electronic feature, or they can be mitigated and safely landed. We would take control of that drone and safely land it to an area where we can further investigate.
Okay. Oh, so I understand. So this is like events where we're going to protect the airspace. So that means like, we're controlling the airspace around this event just to ensure public safety.
Correct.
Okay, very good. Thank you.
You're welcome.
Seeing no further questions, thank you for your testimony. Next in support, please come forward.
Mr. Chairman, Shannon Cooper today representing the City of Kansas City as well as the Greater Kansas City Chamber of Commerce. We just want to go on record in support of the bill. I think you guys had all your debate yesterday and passed it out, so be happy to answer any questions.
Any questions? Seeing none,
Thank
for
you.
your testimony. Let me go to opposition real quick because I strayed from what I usually do. Are there any opposed to 2587? Seeing none. Going back to those in support.
Good morning, Mr. Chair, members of the committee. Chance Hepla here on behalf of the Missouri Chamber of Commerce and Industry. We just want to go on record in support of this legislation with the contingency that this bill is reflective of the language that was passed here in the Senate. I know there are some brief stipulations from our end, but we're very agreeable to the language and we're happy to go on support. Really appreciate all the parties that have been engaged, Highway Patrol, Public Safety, every party that's come to the table, and so we really appreciate them. And so we agree with the bill itself and also to the sentiment of public safety. I know for the Chamber and our members, that is top priority for all of them. And so, again, happy to go on support, happy to take any questions.
Any questions? Seeing none. Thank you for your testimony
Thank you.
today. Any further in support of 2587? And we're going to move these to 1 minute as we still have one bill left.
Thank you very much, Mr. Chairman, members of the committee. My name is Arnie C. A.C. Dinoff, State Public Advocate. I submitted my testimony in the Senate portal. I supported this back a few months ago, or about a month ago, in the House committee. I think it's a good bill to ensure general public safety of the airspace with a major event. I do have a couple issues that I'd like to bring to the committee's attention. Number one, I want to ensure that the First Amendment is strictly adhered to and that the media and press who are covering the event or covering a sporting event, the sporting action, that they are not taken down or removed from doing or broadcasting to the general public. The warning system. I don't know how exactly you warn or you communicate with an unmanned drone. So I'm not exactly sure how that occurs, but I think it needs to be a definite warning, and hopefully the owner or the flyer will heed that warning. And finally, if law enforcement wrongly damages, I think that there should be responsibility. If they take somebody from the media or the press or a news outlet that's covering the event, if they wrongly damage their drone, I believe that they should be responsible for that financial damages. For those reasons, I support the bill, HB 2587. Thank you.
Thank you, Mr. Dienoff. Any questions? Seeing none, thank you for your testimony and your awesome patriotic shirt again.
Thank you.
He changed it up. We had St. Patrick's Day, and he changed it back to honoring America. Any further in support of 2587? Seeing none. Any for informational purposes on House Committee Sub, House Bills 2587? Seeing none, that'll conclude the public hearing on House Committee Sub for House Bills 2587. Moving to the last bill, House Bill 3146 by Representative Simmons.
Thank you, Chair. Thank you, Committee. For the record, Representative John Simmons, representing freedom-loving Franklin County, District 109. 3146 is basically Senate Bill 22 2.0 from last year. Supreme Court about 2 months ago passed a ruling that basically gutted that proposal, and so basically 3146 reinstitutes a lot of the measures except the last part, which was Section 526.010, which was the authority for the AG doing some preliminary injunction appeal. So we struck that out and put the other good measures that Senator Brattin's bill put in originally last year, and that's bringing the ballot summary language from 50 to 100, making that consistent with the initiative petition process. And there's also a setup between giving authority to the Secretary of State's office and the courts if there is a challenge to the ballot summary statement, and that basically there's, as I think Senator Brattin mentioned, 3 bites at the apple as far as trying to get the statement proper if the courts thought there's a challenge about the fairness and the sufficiency of it. And so it basically, during odd number of years, there's a 7-day window that the SOS can write the language and give it back to the circuit court. Second bite is a 5-day window, and then a 3-day window. On even years, during election year, we did modify this in our House committee discussion, that during even years, election years, that back and forth will actually start with a 3-day window, then a 2-day, and then a 1-day window. It still keeps in check the last part of the bill on the last 2 pages, where signatures that are gathered related to the ballot summary, as they're challenging maybe the exact wording of it, you're not going to discount. You're still going to keep valid those signatures that were gathered for that ballot measure, so that protects the constituents that way. And then as the appeal process goes on, if there is an appeal process to the appellate level or even the Supreme Court, they can still opine and give basically revision suggestions as to the legal flaws as they see it, but we still have the Secretary of State writing that. In the end, after that 3rd attempt, then the circuit court can actually write the ballot summary language. And for that, because of time limits, I will leave it there.
Thank you, Representative. I think this is almost identical to what was negotiated last year between both parties, sent over into the House. Except for that one piece dealing with the Attorney General.
Yeah.
And like you stated, maybe some tweaking on the timing issue, but substantially this is what the Secretary of State was implementing on several ballot initiatives. In your opinion, was that working?
It
balancing
was,
the powers?
And I'm glad you brought it up, because actually it was put into effect when we had the Amendment 3, the new Amendment 3. There was a challenge to that, and so the Senate bill before the Supreme Court made its decision, that was the law of the land, where that process of back and forth, and so it actually went 2 times. After the second attempt at the Secretary of State, the court found that new language was fair, was sufficient, and that was the ballot language using those 100-word limit. So it was actually put into practice right away, and it was a beautiful thing to see.
Thank you. Any questions? Seeing none. First witness in support, please come forward on Senate Bill 3146.
Byron Keelan, President of Freedom Principle, here to speak in support of 3146. At the heart of the legislation is the reaffirmation of the role of the Secretary of State as a constitutionally elected official charged with specific duties by the Missouri Constitution, including the critical task of certifying ballot titles for initiative petitions and referenda. Nowhere in the Missouri Constitution is the judicial branch granted the authority to directly rewrite the ballot language. And this bill does not deprive citizens of a judicial check on the fairness of ballot titles. Rather, it preserves a path for a challenge and for the courts to ensure impartiality. The procedural safeguards in this bill allow courts to remand insufficient and unfair summaries back to the Secretary of State, who must then, as an elected and accountable official, make the required corrections. This bill strengthens transparency and trust in both our elections and our state systems of checks and balances. It upholds the separation of powers as is laid out in the Missouri Constitution and makes clear that the power to craft ballot language, an inherently political and administrative task, rests with the elected Secretary of State, not with unelected judges. Judicial review remains intact, but judicial authorship of the ballot language does not. Thank you.
I would ask any questions, but I don't have any. So thank you for your testimony.
Yep. Thank you.
Moving to those opposed to 3146.
Good morning, Senators. My name is Denise Lieberman. I'm the Director and General Counsel of the Missouri Voter Protection Coalition. We're Missouri's nonpartisan voting rights organization who work to ensure that voting is free, fair, and accessible to all Missourians. I've been a voting rights attorney for over 25 years and come today to express Missouri Voter Protection Coalition's opposition to House Bill 3146, which we believe would contravene the balance of powers by preventing courts from timely remedying illegal and unfair ballot language and incentivize political actors to run out the clock and allow fair ballot language to stand. In the past, this legislation has run its course through the elections committees, and in the House this went through the elections committee, but here we're in the Judiciary Committee. So let's talk about the role of the judiciary. The balance of powers that undergirds our entire democratic system and constitutional government is critical to allowing courts to correct legally flawed language proposed by the legislature or Secretary of State in initiative or referendum processes. Courts should retain the authority to edit the language, summary language, that they have concluded runs afoul of Missouri law. Missouri law requires summary language that voters see to be sufficient and fair. For good reason. Voters deserve to know what they are voting for. And while the authority rests with the Secretary of State to draft the summary language for citizen initiatives, or the legislature to draft that summary language for legislatively referred proposals, it is the job of the courts to determine their legality and remedy those illegalities. And that is what House Bill 3146 strips, and in doing so contravenes the critical balance of powers that has been the foundation for our constitutional government since the dawn of this country, since 1802 in the Supreme Court's decision in Marbury versus Madison that held that courts do have the power and the authority to assess and remedy illegal acts of the other branches. This legislation does not stop the legislature or the Secretary of State from exercising their authority to draft these statements. Rather, it says, but it would stop the courts from their obligation to hold those actors accountable for doing so within the bounds of the law. Because this legislation would effectively block the court's ability from remedying illegal ballot summary language until after the Secretary of State has had up to 4 bites at the apple, causing lengthy delays and more voter confusion, we urge this committee to vote no on House Bill 3146. I'll note that I'm submitting written testimony here today from the Missouri Voter Protection Coalition, as well as on behalf of several of our members who, because of the barely 24-hour notice of this hearing, were unable to make it today, including our board president, Beth Franklin.
Thank you for your testimony. Unfortunately, with the committee structure, it'll get distributed, but only those who are here testifying will be actually put into the record. But we will get that to the other members who are here or who aren't here as well. Any questions? Senator Brattin.
Make sure my office gets that testimony. Thank you.
Any further questions? Seeing none. Now moving back to those in favor of House Bill 3146. We're going to move expeditiously. We have 15 minutes, and then another committee is behind us.
I'll be super quick. Lisa Panett, Armorvine. We believe that it's great legislation and that the courts still retain their authority because they get to work with the Secretary of State 3 times, and then the court still retains all the authority it had before. So,
any questions? Seeing none. Thank you for your testimony. Moving back to those opposed to Senate Bill 3146.
Thank you, Mr. Chairman, members of the committee. My name is Arnie C., AC Dinoff, State Public Advocate. I submitted my adamant opposition to this legislation on the Senate online portal. As I testified in the House, I testified very extensively. First of all, I want to start out by saying I believe in fair elections across Missouri. Second of all, this issue brought out a lot of people from the public to testify on the House side. There were 497 submittals from residents across our state. I believe there were 7 to 9 that were in favor, and there were over 490, I believe 490 that were in opposition. And I would ask the committee members to look at that testimony. I believe in our courts. I believe in our judges who can make sure that we have the separation of powers and not one segment of our state runs away with all the power. The last couple election cycles have been daunting, expensive in litigation, and not showing Missourians that Missouri state government cares about elections. I believe in the writ of mandamus and election administrative review. I was involved in a court case that set many court precedents in terms of election law. It was Arnie Dinoff and State of Missouri versus the St. Charles County Ambulance District.
Arnie, your time has expired. I'll give you a couple seconds to wrap up.
Thank you, Mr. Chairman. I believe that election administrative review needs to be the forefront, and Missouri citizens need to be protected. The rewriting needs to be in the court's authority. In my opinion, this HB 3146 is disenfranchising our 6.2 million Missourians. It will again be struck down by the Missouri Supreme Court. It will be expensive to taxpayers. I need to stand up for Missourians who cannot be here to testify. And as a matter of fact, if this bill is signed by the governor, I will file a lawsuit challenging the validity and constitutionality of this awful HB 3146. The court has spoken very clearly on many elements, and we need to ensure that our citizens are first over politicians and elected officials.
Thank you,
Mr. Chairman.
Any questions? Seeing none. Going back to those in favor of House Bill 3146, we're going to move to 1-minute testimony.
I'll be super quick. Mike Compton again with Act for Missouri. We just want to go on record in support of this bill.
Thank you for your testimony. Any questions? Seeing none. Those opposed to House Bill 3146, please come forward.
Good morning. My name is Kay Park, and I'm here on behalf of the League of Women Voters of Missouri to strongly oppose HB 3146. A citizen-led initiative petition is an arduous process that can only be accomplished when thousands of Missouri citizens are committed to an issue that affects everyone in the state. HB 3146 uses that position of one person, the Secretary of State, to sabotage the efforts of thousands of people. The state of Missouri has a history of deliberately fabricating misleading summary statements to thwart legislation that they don't like. This bill would allow the Secretary of State 3 times to rewrite that ballot summary. We have checks and balances in government to combat this very behavior. The courts are in place to prevent the overreach of power of other parts of government, including the Secretary of State. If the Secretary of State does not write fair and accurate ballot language on the first try, he does not deserve a second chance. In fact, if that happens on more than one ballot initiative, as it has in the past, it proves that he's either not competent or he's biased and he should be removed from that position. It's critical the ballot summaries are accurate and not misleading for voters to make informed decisions. Voters should be able to trust that summary on the ballot language.
While your time has expired, I see your written testimonies there. If you want to submit that, we can get that to all the members.
Okay.
Are there any questions? Seeing none. Thank you for your
Thank you.
testimony. Next, in favor of 3146, please come forward. You will have 1 minute, and we have roughly 10 minutes left.
Thank you, Mr. Chairman, members of the committee. Samuel Lee, registered lobbyist of the Campaign Life Missouri, just to go on record in support of House Bill 3146. And I've submitted my testimony online.
Thank you for your testimony. Any questions? Seeing none. Moving back to those in opposition, 3146.
Good morning, Mr. Chairman and committee. My name is Rob Didrikson, and I am speaking in opposition to House Bill 3146. I want to start with a confession that sometimes I'm blind to my own behavior. I can have good intentions, but I end up stepping on the toes of others that I didn't because I couldn't see the full picture, right? So today I have to wonder, are our political parties becoming so rigid that they are blind to their own behavior? To me, this is about truth and labeling. If I buy a carton of milk and the label says fresh, but the fine print says it expired last month, I've been misled. We wouldn't accept that kind of fine print at the grocery store, and we certainly wouldn't accept it when buying a used car. Why should a constitutional amendment, the highest law of our state, have a lower standard of honesty than a gallon of milk? We deserve to know exactly what we're voting for. And I want to also point out that Missouri's, we don't have to guess if the initiative petition process works. It's been working for Missourians for more than 100 years. And we only have to look at our very own Missouri Department of Conservation. In the 1930s, Missouri's wildlife was decimated.
While your time has expired, I'll give you a couple seconds just to wrap up.
Okay. I want to encourage, basically to refer to the welfare of the people, or, the state motto, the welfare of the people should be the supreme law. It doesn't say the welfare of a party or donor. And I urge you to vote your conscience on this bill. And not shut us out of having a voice in our own government.
You can submit that written testimony if there's anything else in there. Any questions? Seeing none. Next, in favor of 3146.
Thank you, Mr. Chairman, members of the committee. For the record, Susan Klein, representing Missouri Right to Life. Here to go on record in support of House Bill 3146, and we appreciate your support of this bill.
Any questions? Seeing none. Thank you for your testimony today. Moving back to opposition, House Bill 3146.
Thank you, Nancy Copenhaver, excuse me, from Moberly, speaking in opposition to House Bill 3146. It would create a lengthy, unnecessary, and complicated process to challenge an unfair and misleading summary statement of any ballot measure. Voters deserve fair ballot summaries because they are critical to our 100-year history of direct democracy. And as a League of Women Voters member who has supported many of these issues, I want to say that sending this back to the Secretary of State for rewrite 3 times is just silly. This would negatively impact the time needed to inform voters about a ballot issue. When this was first proposed, I talked to several people about it, and everybody I've ever asked has said the idea of having 3 chances to rewrite something so that it is true and accurate is just downright silly. Let's let the courts decide whether something is appropriate or
While
not.
your time has expired, I'll give you a couple seconds to
Thank
wrap
you.
up. Thank you. Any questions? Seeing none. Thank you for your testimony. We're moving back to those in support of 3146. Seeing none. Those in opposition to 3146.
Morning, Mr. Chairman, members of the committee. I am Kelvin Simmons, contract lobbyist here on behalf of Health Forward Foundation of Kansas City. We are in opposition to 3146. We've basically uploaded our testimony, and if you have any questions, here to answer any questions you might have.
Thank you for being present today. Any questions? Seeing none. Any more in favor of 3146? That will conclude those in favor. Going to those in opposition.
Good morning again. Jonathan Schmidt on behalf of the American Civil Liberties Union, going in, on the record in opposition to House Bill 3146.
Thank you for your testimony. Any questions? Seeing none. Any further in opposition to 3146? Okay.
Morning, Mr. Chair, members of the committee. My name is Ron Berry. I'm here on behalf of Jobs and Justice Voter Action. We just want to go in record in opposition to this bill. We have a lot of concerns with the back and forth with the summary statement.
Thank you for your testimony. Any questions? Seeing none. Any further in opposition to 3146? Seeing none. Any for informational purposes on 3146? Seeing none. That'll conclude public hearing on House Bill 3146, and having no further business for the committee, I now move that we adjourn. Do I have a second? Having a second, we are adjourned.